Welcome to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from the law offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Wednesday at 5:30 p.m. EST with attorney Ms. Prashanthi Reddy in English, on Thursday at 5:30 p.m. EST with attorney Chand Parvatneni, and on Friday at 6 p.m. EST with attorney Bhanu Libra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi needs no introduction. But if you need consultation, please log on to reddyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The reddyesq.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the dependent visa's do's and don'ts, options after separation, divorce, or death. We will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. And before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. Hi, Ms. Reddy. How are you doing?
Hi. Hello. How are you? Sorry for the late start. As you know, we've had some technical issues. So There might be some issues with the video quality, but we'll try our best.
Right. So, Ms. Reddy, today we're actually talking about a very different topic. And I'm sure, you're going to give us a lot of information about this new topic. We're talking about the dependent visas, H2s, L2s, F2s, and, what are the do's and don'ts. So before we get into the topic, do you have any immigration updates to share with us, Ms. Reddy?
No updates.
Right. So we're also talking about options for a dependent, after separation or divorce or, their spouse's death, who's the primary principal visa holder. So let's first talk about, the options of a dependent visa and, in case of death. So what if a dependent visa person or a holder who's waiting for their visa, has not gotten their visa approved and their spouse or their partner, who's the primary visa holder, dies? What are their options? Will they still get their visa?
Yes, they can, but I just wanted to segue first into what is a dependent visa, and just give a short presentation, if I may, about what is, what is a dependent visa, what are the different kinds of dependent visas, and then Torni, I will answer that question for sure.
Right.
So there are different kinds of dependent visa. Is pretty much a dependent visa, which basically means that people who are spouses or unmarried children. So children under 21, they are dependents. Unlike India, parents are not dependents. So parents will not get a dependent visa, but spouses and children will. So since there are different categories, different non-immigrant categories, there are also different dependent visas. So, and every non-immigrant category has its own dependent visa. So for example, F1, if you come on a student, then the dependent visa for your spouse and children will become F2. On an F2, an individual who's on an F2 receives the dependent visa based on the I-20. So the I-20 will have to basically mention all the dependents' names, and only then will, the consulate actually give the F1 dependent visa. You can also the F2 dependent visa. You can also file, if you're in the US, you can file a change of status to an F2 visa if you're in some other status by filing an I-539 application. The other dependent visa is the H4 dependent visa, most commonly used. This is for spouses and children of individuals who are in the H1B category. For such people also, you can either go directly to the consulate and get a H4 dependent visa by showing relationship documents, showing that how you're related, showing proof of relationship. If you're a child, then you need a birth certificate, which has your the principal's name on it. If it's your father, then the father's name. If it's your mother, the mother's name on the birth certificate. That shows proof of relationship. If you're a spouse, dependent spouse, then you need to have a marriage certificate issued by recognized authority. That serves as proof of relationship. For a H4, you fill out, you basically go with these documents. You also have to show proof of the principal applicant's status, meaning you have to show the proof that they are in valid H1 status. So in order to show that, you'll have to show their H1B approval. You'll have to show their latest pay stubs so that we know that they're working for a company and they're not out of status. So that is your H4 dependent. In addition to that, you also have J2. So the H4, the other thing that I wanted to say about the H4 dependent status is some H4 dependents can work. For the F2 dependents, F2 dependent cannot work, but they can study as long as it's not full-time. For a H4 dependent, they can go to school again as long as it's not full-time, but they cannot work unless the principal applicant, the principal spouse has an I-140 approved. So if they have an I-140 approved, the I-140 is the second step in the green card. If you file a labor, then you file the I-140. Once it's approved, your spouse will get an EAD. In order to apply for an EAD, the H4 dependent spouse has to fill out an I-765 form. And usually this is given for a year at a time. In addition to that, as I said, J2, almost the same thing. J2 dependents can work by filling out an I-765 and getting an EAD. For an L2, it's interesting, a little different. L2 is the dependent of an L1, and L1 is a intra-company transferee, a person who's being transferred from in a multinational company from one country to another to look after their branch office or subsidiary in the US. Now, an L2 dependent can attend school, and as long as it's not full-time, and the children, of course, can attend school. And the L2, the interesting part about the L2 visa is the L2 dependent spouse can work automatically. They don't have to obtain an EAD. There's nothing further that they need to do. They can just automatically work. So that's one good thing really about the L2 visa. Some other visas are the K visa, which is if you are a fiance of a citizen, then you can apply for a K visa and come on a K non-immigrant visa as a dependent. And then there are certain requirements. You have to get married in 90 days and then file for the green card. M2 visa is basically dependent of an M1, and M1 is basically a student, but a student in which a certain type of student where they're taking not just classes, but they have some practical experience as well, and that's taught to them as well. So there's a slight difference between an M and an F. Also, there are some issues with the dependents with reference to who qualifies. So as I said, a dependent spouse qualifies, a child qualifies, but the child has to be unmarried, biological child, so not a child out of wedlock, under the age of 21. So all these things are needed. Biological child out of wedlock, then you need bona fide proof from the parents that so that it becomes a little complicated. Okay, so these are the conditions for getting a dependent child visa. In addition, also to get the documents to get the kind of documents that are needed to get a dependent visa in the US are birth certificate, also, as I said, marriage certificate, passports. These are some of the documents needed to actually get the visa. So as long as you have all this, and of course you have to fill out, if you're outside the country, then you're filling out the DS 160. And when you fill out the TS 160, then they'll ask you for all these documents. You have to take an appointment to the consulate, pay the applicable fee, etc., etc. So with that, I think I just wanted to give a quick overview of
Right.
what a dependent visa is. You can go ahead now, Thorny, with I think the question that you had. Let me answer it since you already asked me the question. Thorny's question was, and since we're also a little short on time, Thorny's question was, what happens if there is a person who, under unfortunate circumstances, if the spouse dies, then what happens to that dependent? What happens to their status? So in general, for example, if a person is on H4, and recently there was a case actually where that had happened, the person had an accident, spouse passed away, and now the dependent H4 spouse is in the country with a small child, and she really is trying to figure out how she can stay in the country. So there are two aspects to it. One is you have to maintain your non-immigrant status. In order to do that, you would have to file then a change of status as soon as you can, because the moment your spouse doesn't exist, then you no longer have a H4. So you have to really depend on humanitarian grounds, filing on the basis of humanitarian grounds for a change of status application. It's called a nunc-pro-tunc application. And most of these cases are approved as long as you have a valid application to change to. So, for example, you can get admission in a school on an F1. And, this can help. So by getting an I-20 admission into a school, then you would file for a change of status from a H4 to an F1. Of course, there are problems with this approach because a change of status from H4 to F1 is taking about 10 months now. And, it has to coincide, the approval has to coincide with the start date of your classes. So luckily, recently, last year, there was a law which said that if there is a gap between the time that, your classes actually start and the approval of your case, USCIS will forgive that gap. So that is good news for a lot of people. So because there will be a gap between the time that you start and the time that your H4 actually was invalidated. So that is good news for a lot of people filing a change of status. Also, a H4 person temporarily could file a change of status to, say, a B2. But that's, of course, again, temporary. You can only be on a B2 or a visitor's visa for 1 year, and you're not allowed to work on that visa. Of course, you could always file for a change of status to a H1. Again, there are constraints for that because for a H1, there is a cap. So if you are filing during the time where, the cap is over, then you'd have to wait until the next cap season. For example, you can't file now. Unless you're working for a non-profit organization, then you could because that's cap exempt. Otherwise, you'd have to wait until the next cap opens up, which would be March of next year, and then try your luck with the lottery. So as you see, there are a lot of constraints, and there's no law which really allows, addresses this particular situation. However, there is a law which, if you're able to maintain your status, then there is a law which will allow you to, once, say, you are able to maintain your non-immigrant status and your spouse started the green card application, and then the spouse passes away, you will still get your green card based on, INA 204I. Based on that new provision in the law, you will still be allowed to get your green card even though your principal applicant has passed away. So say you filed an I-140, your spouse filed an I-140 and it got approved, or they filed a 485 and it's pending. Whatever the situation might be, you'll be able to continue that as long as you maintain your status. So the applicant, in order to qualify for the continuation of this green card, there are certain conditions that have to be met. So the applicant has to be residing in the United States when that when the spouse passes away or qualifying relative passes away. It could be a parent as well. The applicant continues to reside in the United States on the date that the decision on the pending application was made. So whenever the I-140 was approved, you should have been continue staying in the United States, not staying somewhere else. And also beneficiary, the other conditions are the beneficiary should be, the applicant should be the beneficiary of a pending or approved immediate relative petition. So either your spouse should have filed a I-130, which is a family-based petition for you, or a pending or approved family-based visa petition. So it could be there is an immediate relative petition. There's also petitions where you may not necessarily be an immediate relative, but you're still qualified, right? There are different types of family-based green cards. So whether it's immediate relative as well as other relatives like brother, sister, that applies as well. Also, a derivative beneficiary of a pending or approved employment-based petition. So this is the H4 scenario we were talking about, where the person filed an I-140, got approved, spouse passed away, 485 is pending, so they're allowed to, continue to get a green card based on that. Also, if the spouse was the beneficiary of a pending or approved asylum or refugee petition, or derivative T or U petition. So these are all the qualifying petitions and relationships based on which a person can continue to get the green card under this new requirement. I can continue on this topic, or we can move on to Q&A.
Right, but I also wanted to ask Ms. Reddy if since these are dependent visas, do they also have premium processing?
So dependent visas by themselves don't have premium processing. A H1 will have premium processing, but not a H4. Unfortunately, and that's why what's happening is a lot of H4s, it's taking a long time to get approved, and since they're able to work whenever they need to file that extension, they have to be out of work for a long period of time because it's taking 10 months, 12 months for the H4s to get extended. So that's a real problem. USCIS has come up with some solutions, but they're not 100% effective.
Right. Right. And also regarding, since we've already spoken about a scenario in case of death, but there's also divorce and separation. And largely, before we get into the topics individually, I wanted to ask if largely there is too much difference between a divorced scenario and a separated scenario.
Yes, huge difference.
Are there laws that are different, or is there a process that's different? If you could.
So the difference is when you're separated, you can continue to be on a H4. You don't really have to change status. You're not losing your status because you continue to be that person's spouse, whether they like it or you like it or not. So even though you're not getting along, you still qualify to be on a H4. But there are a lot of practical problems that happen with a separation. I mean, the main issue is the logistics of getting your spouse's information for you to be able to file a H4 extension, for example. If your H4 extension is not expiring, if your H4 is not expiring, then you're fine. You continue to be on a H4 until, until a divorce is finalized. Then, of course, then you'll have to do something about it before that. But if you're continuing to be separated, then you continue to be on a H4. But in order to file an extension, you would need your marriage certificate, you would need your spouse's pay stubs from his company, you would need his latest H1B, and he or she may not be willing to give you that information as you're separated and maybe not on good terms. So it becomes a practical problem as to how to show proof of relationship, because for H4, when you file an extension, you have to submit all these documents. So in that scenario, you might, what you need to do is maybe file for an extension with the documents that you have and put in a letter. If there is abuse or there's some other serious reason for separation, you can put in that information as well and say, because of that, all this is happening, you're not able to obtain the documents required and to approve the case without those documents on a non-proton basis, on humanitarian grounds. And that happens sometimes. So that is the effective way to go in such a situation. With reference to a divorce, the difference is here you are no longer the spouse of a H1. So if you're no longer a spouse of a H1, you're no longer qualified to be on a H4. So before the divorce takes place, you need to figure out what you want to do. You have to file for a change of status, either to an F1, as we spoke about earlier, or to a H1 if you're able to, or a B2. So depending on what your circumstances are, or you have to leave the country if you're not able to file for anything immediately, and then come back on whichever status you're able to come back on, either an F1, apply from the consulate, or H1 for next year's quota if the quota is over, whatever the circumstances might be. So you really have to weigh the pros and cons of filing a change of status, which kind of change of status to file, or whether you should leave and just file for consular processing and come back on a fresh visa. So every circumstance is different. I mean, I suggest you talk to your attorney and figure out what the best option is for you.
Right.
Yeah.
While we're on that topic, no, I was listening, of course, Ms. Reddy. While we're on that topic, I wanted to also ask, when divorce harassment or a dependent's visa, visa approval while it's still in pending, and how do we handle that? I mean, what can be done in those cases? And this would be my last question for the session today.
Sure. You were breaking up a little bit. Can you ask the question again?
So when it involves domestic harassment or anything that surrounds family law, how is the treatment different? Is the processing time longer, or is that taken into consideration as well?
Right. So domestic violence. First thing is, if there's domestic violence, you can apply for a special kind of green card if your spouse is a US citizen or a permanent resident. It's called the VAWA, Violence under the Violence Against Women Act. You can actually file for a direct green card without the help of your husband, by yourself. It's called an I-360 application. So you can get a green card based on that. You have to show that there was domestic violence. And domestic violence is shown, of course, you can't do that if your spouse is a non-immigrant, but only if he's a permanent resident or a US citizen. Domestic violence documentation is very important. You either get affidavits from your families and friends, relatives, or you get information, say maybe you filed a complaint, a police report. You have a police report. The cops came and they filed a complaint. You get a copy, include a copy of the complaint. If you have undergone psychological evaluation, get a copy of that. If there's been a decision by a court, by a judge in a criminal case, if there was abuse, if there was violence, then you could attach a copy of that as well. So this is all this shows domestic violence. So you can prove that and get a green card directly by self-petition. So that's one good law they have with reference to people who have to, undergo domestic violence. If you're a non-immigrant, again, you have the same problem. The issue is you're separated, most probably, or you're not separated, but your spouse is uncooperative, so they're not able to get the documents to you. Then you submit all these documents. You submit all this to show that there's been abuse in the relationship, and file for a nunc-pro-tunc H4 extension or change of status if you want to become independent of his immigration status. And that's the way to go.
Right. So with that, Ms. Reddy, unfortunately, we have to end our show, this episode, and we will definitely continue this in our next week's show. And it's always a privilege hosting you, Ms. Reddy. Thank you.
Thanks, Tony. Take care. Bye.
You're watching Sakshi Live. This is Torni. Thank you.